Territories. Archibald arrived at his new post in September of 1870 with the following instructions from the Dominion government. You will, with as little delay as possible, open communications with the Indian bands occupying the country lying between Lake Superior and the province of Manitoba with a view to the establishment of such relations as may make the route from Thunder Bay to Gary secure at all seasons of the year. You will ascertain and report to His Excellency the course he may think most advisable to pursue, whether by treaty or otherwise, for the removal of any obstruction to the flow of population into the fertile lands. It is clear from these instructions that the federal government wanted to open up the West for settlement. In 1871, the Secretary of State, Joseph Howe, appointed W. M. Simpson as Indian Commissioner to treat with the Indians between Thunder Bay and Fort Garry. On August 3, 1871, the Saugeen First Nation, or the Fort Alexander Band, as it was known then, entered into a treaty with the Crown. According to the written terms of Treaty No. 1, the following was promised. The annual payment of $3 to each band member, set apart reserves based on 160 acres per family of 5, maintain a school on the reserve. These obligations are specifically mentioned in the treaty. However, other promises were made outside of the written text of the treaty, which are known as the outside promises. These are not contained in the actual Treaty No. 1 text, but were later added in 1875. These included the increase from $3 to $5 as a treaty payment, domesticated animals, agricultural tools, suit of clothing for the chief and councillors every 3 years. It should be noted that the numbered treaties are complex legal documents that contain a technical language that is difficult to understand. Just imagine how difficult it would be to understand what the treaty was about in 1871 because of the legal and technical phrases contained in the document if you were not familiar with English or with the written English language. Because the treaty commissioners did not speak the First Nations languages, they used translators in an attempt to convey the terms of the treaty to the First Nations people. In most cases, the First Nations leadership did not understand the English language. Because of the language barrier, it is clear that the two different understandings would emerge from the interpretation of the treaty. According to Alexander Morris's book, The Treaties in Canada with the Indians of Manitoba and the Northwest Territories, he quotes Lieutenant Archibald opening Treaty No. 1 negotiations with the following statement. Your great mother, the Queen, wishes to do justice to all her children alike. She will deal fairly with those of the setting sun, just as she would with those of the rising sun. She wishes her red children to be happy. She will make rules to keep them for you. So as long as the sun shall shine, there shall be no Indian who has not a place that he can call his home, where he can go pitch his camp, or if he chooses, build his house and till his land. It is a historical fact that Lieutenant Archibald did not speak the Ojibwe language. It is well known by First Nations people who are fluent in their own language that you cannot accurately translate a complex, legal, technical English sentence into a First Nations language and have the same meaning. To illustrate this point, I would like you to consider the following text taken from Treaty No. 1. The Indians inhabiting the district defined do hereby cede, release, surrender, and yield up to Her Majesty and successors forever all the lands including within the following limits. Just imagine how this legal meaning regarding this Aboriginal title can be translated to First Nations language. As you can just imagine, it must have been very difficult for the First Nations people to accurately understand what the government's perspective was regarding the treaty. Because there are varying views of the treaties by First Nations and the federal government regarding the interpretation of the treaties, such as hunting and fishing rights, it is the courts that decide what those rights are within the law. Since there have been hundreds of court cases in the past to interpret the treaties, it is important to note a few legal principles that have emerged from these cases to form a foundation to guide the present court cases. Some of the notable principles are: treaties must be construed not according to the technical meaning of the words, but in the sense in which they would be naturally understood by Indians. It is important to consider the history and oral traditions of the Indians concerning the surrounding circumstances at the time the treaty was signed to determine the effect of the treaty. One of the most important decisions to date is the Supreme Court of Canada's ruling in Delgamuukw, where Chief Justice Lamer affirmed the importance of considering the oral histories on equal footing with other historical evidence. The actual wording in the decision is described here. Not challenges created by the use of oral histories as proof of historical facts. The laws of evidence must be adapted in order that this type of evidence can be accommodated and placed on an equal footing with the types of historical evidence